The real story is in the details most reporters missed. The Supreme Court issued a ruling against the Trump Organization in the civil fraud case. The media called it historic. Analysts discussed the financial implications. Political commentators debated the electoral impact. But buried in the technical language of the decision on page 58, footnote 23, three sentences appear that transform the meaning of everything else. The court wrote that its findings established predicate grounds for referral to appropriate prosecutorial authorities regarding potential criminal liability, extending beyond the civil violations adjudicated in this matter. Let me translate that from legal language to plain English. The Supreme Court just told federal prosecutors, we examined the evidence, we documented the patterns, we established the legal foundation. Now you have authorization to proceed with criminal charges if you choose to do so. This isn't a civil penalty, this is a roadmap, and the timing is not coincidental. This ruling dropped exactly 14 days before Jack Smith's filing deadline in the federal election interference case. The Georgia grand jury reconvenes this week. The New York sentencing hearing, postponed 3 times previously, is now scheduled for Wednesday. 3 separate prosecutorial tracks, 1 Supreme Court ruling that affects all of them. This is what legal scholars call convergence, and it changes every calculation. Now, let me show you what's happening in the Republican establishment, because this is where the structural analysis becomes important. When legal pressure intensifies on a political figure, the people around that figure face a choice. Do they maintain loyalty and share the exposure, or do they create distance and preserve their own positions? The signals emerging from Republican circles suggest that calculation is happening right now. Major donors are reassessing their commitments. This is documented in financial disclosures and reporting from multiple outlets. When legal uncertainty increases, political money becomes cautious. Donors who were comfortable writing large checks when the legal picture seemed manageable become hesitant when that picture darkens. The pattern is visible in super PAC activity. Commitments that seem solid are being reviewed. Fundraising events are being quietly postponed. The language in donor communications has shifted from confident to conditional. This isn't unusual. It's how political money has always responded to legal exposure. What's different is the scale and the speed. Republican senators who have consistently defended Trump are facing a new calculation. The Supreme Court ruling wasn't a 54 partisan split. It was unanimous. That means Trump's own appointees, Gorsuch, Kavanaugh, and Barrett, examined the evidence and concluded they could not defend the conduct at issue. When your own appointees rule against you unanimously, the political cover evaporates. Senators can no longer frame criticism as partisan overreach. The highest court, including justices selected specifically because they were expected to be sympathetic, looked at the facts and reached a unanimous conclusion. That changes what senators can say publicly, and more importantly, it changes what they're willing to risk privately. Let me explain why Chief Justice Roberts wrote this opinion himself, because that detail reveals the institutional thinking behind the ruling. In most cases, Roberts assigns the majority opinion to another justice. He reserves his own pen for cases where he believes the court's institutional legitimacy is at stake. Roberts understands something that most political commentary misses. This case isn't primarily about Trump. It's about the next person who attempts something similar. It's about whether the legal system can establish boundaries that apply regardless of political prominence. During oral arguments, Roberts made a statement that deserves more attention than it received. He said that if the court allows systematic fraud to hide behind corporate structures simply because the individual is politically prominent, then they are not protecting democracy. They are undermining it. That's not a political statement. That's an institutional statement. Roberts is betting the court's long-term credibility on establishing a principle that will outlast any individual case. The 3 Trump-appointed justices signed the opinion without writing separately. No concurrences, no individual explanations of their reasoning. Complete silence beyond their signatures. In judicial practice, that silence is meaningful. When justices want to signal reservations or provide alternative reasoning, they write separately. When they sign without comment, it typically means the evidence was overwhelming enough that no additional justification was necessary. Whatever evidence was presented in sealed filings, whatever documentation the court reviewed that remains confidential, it was sufficient to produce unanimity among justices with very different judicial philosophies. Now, let me show you the prosecutorial response because this is where legal theory becomes operational reality. Jack Smith, the special counsel, filed a motion Saturday that uses the Supreme Court ruling as foundation. It's a Rule 16 disclosure, which in federal procedure means he's notifying the defense that he has new evidence and intends to use it at trial. The evidence list includes 43 items. Every single one is a financial document that the Supreme Court ruling just made admissible in ways it wasn't before. In Georgia, Fani Willis reconvened the grand jury over the weekend. Grand juries typically don't meet on Sundays unless something urgent requires immediate action. By the afternoon, they had voted on supplemental charges, additions to the existing indictment that require the kind of predicate findings the Supreme Court just provided. In New York, the Attorney General moved from threats to execution. Seizure warrants were served on properties including 40 Wall Street in Manhattan and licensing assets connected to Mar-a-Lago facilities in Florida. This level of coordination across jurisdictions is unusual. Federal prosecutors, state prosecutors in Georgia, state prosecutors in New York, all moving within a 48-hour window following the same triggering event. When prosecutorial action becomes this synchronized, it typically signals one of two things. Either there's explicit coordination, which would raise significant legal questions, or there's implicit coordination, where prosecutors who have been monitoring the same evidence for years recognize simultaneously that the legal landscape has shifted in their favor. The second explanation is more likely and more significant. These prosecutors have been building separate cases based on overlapping evidence. The Supreme Court ruling removed obstacles that had constrained all of them simultaneously. They're all moving now because they all can move now. There's an international dimension that most coverage ignores. Deutsche Bank, Germany's largest lender, issued a statement Sunday reviewing loan portfolios connected to entities named in the Supreme Court ruling. In banking language, that means they're reassessing relationships that have become legally complicated. Foreign financial institutions face regulatory pressure from their own governments. When a major American court finds systematic fraud in a borrower's operations, European regulators expect their banks to respond. Continued lending to entities with documented fraud findings creates compliance exposure. The Saudi Public Investment Fund, which has committed billions to projects connected to Trump properties, announced those investments are under compliance review. Foreign sovereign wealth funds have even stricter governance requirements than private banks. This isn't just American legal exposure anymore. This is international financial exposure, and foreign regulators often move faster than American ones because they have less political entanglement with the subjects of investigation. Now, let me address the arguments Trump's defenders are making, because if I don't engage with the strongest counterarguments, you shouldn't trust anything I've told you. The first argument is selective prosecution. Critics point to the Clinton Foundation, which received donations from foreign governments and used asset valuations that shifted depending on reporting context. If this standard applies to Trump, why not apply it there? The honest answer involves scale. The Clinton Foundation's documented irregularities involved approximately $12 million over 8 years. The Trump Organization's documented misrepresentations involve properties valued at over $2 billion across multiple decades. That's not a political distinction. That's a threshold distinction. Accounting errors exist on a spectrum. At some point on that spectrum, errors become systematic fraud. The Supreme Court found that the Trump Organization crossed that line by a significant margin. Intent matters too. When auditors questioned Clinton Foundation valuations, the foundation cooperated, opened records, and made corrections. When auditors questioned Trump Organization valuations, the response was to double down, to sign certifications that the organization's own accountants flagged as problematic. The difference between negligence and fraud often comes down to response. Negligent actors correct errors when identified. Fraudulent actors continue despite warnings. The second argument is judicial overreach. Courts shouldn't have the power to dissolve businesses. That precedent threatens free enterprise. This argument has genuine merit and deserves serious consideration. Historically, business dissolution follows criminal conviction. Arthur Andersen was dissolved after Enron-related convictions. Adelphia collapsed after fraud convictions. The sequence is typically conviction first, dissolution second. This case reversed that order. Civil finding immediate remedy. The burden of proof in civil court is preponderance of evidence, not beyond reasonable doubt. That's a lower standard producing a more severe consequence. The counterargument is that some business entities exist primarily to perpetrate fraud. When the fraud is structural rather than incidental, dissolution becomes preventive rather than punitive. The Supreme Court found that the Trump Organization's operational model was built on systematic misrepresentation. Allowing continued operation would mean allowing continued harm. Whether that reasoning justifies the remedy is a legitimate debate, but it's a legal debate, not a partisan one. The third argument is hardest to dismiss. Political motivation. The timing is suspicious. A major ruling against a presidential candidate drops during an election cycle. Here's the honest assessment. Is there a political element? Probably. Does that make the ruling legally wrong? No. The evidence trail for this case began in 2019 before Trump announced his 2024 campaign. The appeals process took 4 years, which is standard for complex civil litigation. The Supreme Court doesn't control when cases reach its docket. The timing creates political consequences, but timing alone doesn't invalidate findings based on documented evidence. Now, let me show you what this means for you personally, because this isn't abstract legal theory. These developments have tangible consequences for American families. First, the financial markets. When major legal rulings create uncertainty about significant business entities, markets respond. The Trump Organization's properties include commercial real estate, hotels, and golf courses with thousands of employees and countless vendors and contractors. Liquidation proceedings, if they occur, will ripple through supply chains. Construction companies that did work for Trump properties may face unpaid invoices. Employees may face job losses. Local economies that depend on Trump-branded tourism may see declines. These consequences aren't punishment for Trump. They're collateral damage that affects ordinary people who had nothing to do with the underlying conduct. Second, the precedent implications. The Supreme Court ruling creates legal tools that prosecutors can apply beyond this specific case. The National Rifle Association is already under investigation in New York for financial mismanagement and misrepresentation to members. Before Friday, that was a regulatory problem. After Friday, the precedent exists for dissolution-level remedies. Political organizations across the spectrum should be examining their financial practices. The standard the Supreme Court established doesn't distinguish between left and right. It distinguishes between accurate representation and systematic fraud. Foreign lobbying firms operating through domestic corporate structures face new exposure. Organizations that have relied on legal ambiguity to conduct questionable financial practices just lost that ambiguity. The court loaded a legal weapon. Watch carefully to see who picks it up and how they use it. Third, the institutional consequences. When legal systems successfully hold powerful figures accountable, it strengthens public trust in institutions. When they fail to do so or appear to apply different standards based on political prominence, that trust erodes. Your children will inherit whatever institutional credibility emerges from this moment. Either they'll inherit a system where legal boundaries apply regardless of power and prominence, or they'll inherit a system where sufficient political support provides immunity from legal consequence. That inheritance matters more than any individual case outcome. Now, let me tell you what to watch in the coming days. 4 specific signals will reveal which direction this situation develops. First, watch Trump's legal filings. The language will signal strategy. Technical procedural arguments indicate preparation for compliance. Inflammatory political arguments indicate preparation for defiance. Second, watch Republican senators, not their words, their silences. When consistent defenders suddenly become unavailable for comment, when statements come through spokespeople instead of directly, that's distancing. That's calculation about survival without him. Third, watch Protocol timing. Jack Smith has a filing deadline in 2 weeks, but he might move sooner. New grand jury activity, witness subpoenas being served. These signals indicate acceleration. They suggest prosecutors believe waiting creates risk. Fourth, watch financial flows, not the stock market. Watch cryptocurrency volumes. Watch unusual activity in instruments that are difficult to trace. When sophisticated money starts moving into privacy-preserving assets, it often signals that insiders expect enforcement actions. Wednesday afternoon, Jack Smith's sealed supplement becomes public. Whatever was considered too sensitive to release before the Supreme Court ruled will become visible. That document combined with the ruling will provide the clearest picture yet of where this is heading. Here's what we're actually witnessing. 3 levels of consequence unfolding simultaneously. Personal level. A business empire that has defined one man's identity for 50 years faces dismantlement. Properties liquidated, contracts terminated, a name removed from buildings where it has appeared for decades. Political level, a party fractures not along policy lines, but along a single question. Do you follow the law or do you follow the man? There is no middle position remaining. Every Republican office holder makes that choice in the coming weeks, and that choice defines their political future. Systemic level rule of law versus cult of personality. Can legal institutions actually constrain someone who commands the loyalty of millions willing to reject institutional authority on his word? That's not a political question. That's the fundamental question of whether democratic systems can survive authoritarian impulses. The historical parallel most analysts miss is instructive. This isn't Watergate. Nixon resigned. This isn't Clinton. He faced impeachment, not criminal prosecution, during his term. The closest comparison is Andrew Johnson's impeachment in 1868. He stayed. He defied Congress. And in the aftermath, the country came dangerously close to tearing itself apart. We're now in territory with very few historical parallels. The outcomes are truly uncertain, and the consequences will reach far beyond any one person. Systems don't collapse overnight. They wear down slowly, tested, pushed, and normalized until someone finally draws a line. Right now, those lines are being drawn across multiple jurisdictions at the same time. Whether they hold will shape the legal system your children grow up with, the level of political accountability future generations can expect, and whether power ultimately answers to the law or the law bends to power. Watch the court filings. Watch who stays silent. Watch where the money flows. Those signals will reveal far more than public statements ever will. The next 72 hours won't decide whether democracy survives. Democracy is stronger than that. But they may decide what kind of democracy we become. Pay attention.